Rights of the People by A.T. Jones, Part 2, Chapter 12. Religious Right in the States. It has been shown in Chapter 5 how that upon the victory of religious right in Virginia in 1787, and the nationalizing of those principles by the example and provisions of the National Constitution made in 1787 to 1789, quote, in every other American state, oppressive statutes concerning religion fell into disuse, close quote, and that the Statute of Virginia then established had since been incorporated, always in its principles and often in its very words, in every state constitution in the Union from that day to this. This was not accomplished in a day, however, in the others of the original 13 states. As also formerly stated, all the other states except Rhode Island had established religion in some form. This was so when the National Constitution was adopted, and being so, each state retaining control of its own peculiar institutions, the National Constitution was not made to prohibit state recognitions of religion, but only that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. It was hoped indeed that the moral effect of the example of the National Constitution would lead to the extinction of the thing in all the states. But the difficulties attending the creation of a national power at all were so great that it was essential to attend to this one paramount object, and not try to accomplish too much at once and directly, lest nothing at all be done. Abraham Lincoln's statement of the case as to slavery, the civil despotism, is so precisely the statement of the case as to established religion, religious despotism, that it could not be better defined. Therefore we quote, when our government was established, we had the institution of slavery among us. We were, in a certain sense, compelled to tolerate its existence. It was a sort of necessity. We had gone through our struggle and secured our own independence. The framers of the Constitution found the institution of slavery amongst their other institutions at the time. They found that by an effort to eradicate it, they might lose much of what they had already gained. They were obliged to bow to the necessity. They did what they could and yielded to necessity for the rest. Close quote. Springfield, Illinois, speech, July the 17th, 1858, Political Speeches and Debates, page 160. Read established religions in place of slavery in this passage, and the case is perfectly stated as to that question also. Thus the institution of slavery continued until by a Supreme Court decision perverting the Constitution, an attempt was made to nationalize it when it was abolished even in the states by the 13th Amendment to the National Constitution, which runs thus, quote, Article 13, Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction, close quote. In order that this amendment might be effective in all its scope, it was essential that the basis of citizenship should be changed. Quote, if we were now to have a broader nationality as the result of our civil struggle, it was apparent to the mass of men, as well as to the publicists and statesmen, that citizenship should be placed on unquestionable ground, on ground so plain that the humblest man who should inherit its protection would comprehend the extent and significance of his title. Close quote, Blaine, 20 Years of Congress, Volume 2, page 311. Accordingly, the 14th Amendment to the Constitution was adopted, the first section of which reads as follows, quote, Article 14. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Close quote. Before this amendment was adopted, there was primarily no such thing as citizenship of the United States. Citizenship of the United States came, except to aliens, only as a consequence of citizenship of a state. The reason of this peculiar fact was that the 13 states were all here as sovereign independencies before the United States government was formed, and the people, being citizens of these states to begin with, when these very persons formed the national government, they became, by that very process, citizens of the United States. And as there was no provision in the Constitution touching the subject with respect to any but aliens, the situation still remained the same. Citizens of a state first, and as a consequence of that, citizens of the United States. As stated by an authority in the time when the matter stood thus, it is as follows. Quote, Citizenship, as we understand it, may be acquired in either of two ways, by birth or by adoption, called, when applied to aliens, naturalization. After the Declaration of Independence, and before the adoption of the Constitution of the United States, the power of conferring citizenship by naturalization or otherwise, like all other sovereign powers, was in the several states. And as the power vested in Congress by that instrument applies to aliens only, and as all powers not delegated to Congress by the Constitution, nor prohibited to the states, are expressly reserved to the states respectively, or to the people, the power of conferring citizenship on all persons, not aliens, necessarily remains in the several states, both as to persons born on their soil and as to those born in other parts of the Union, and any person upon whom such rights are conferred becomes a citizen of the state conferring them. And every citizen of a state is, ipso facto, a citizen of the United States. Close quote. Law Reporter, June 1857, page 14. As more fully stated by authority since it was changed, it is as follows, quote, Before the adoption of this amendment, citizenship of the United States was inferred from citizenship of some one of the states, for there was nothing in the Constitution defining or even implying national citizenship as distinct from its origination in or derivation from a state. It was declared in Article 4, Section 2 of the Federal Constitution that citizens of each state shall be entitled to all the privileges and immunities of citizens of the several states. But nothing was better known than that this provision was a dead letter from its very origin. A colored man who was a citizen of a northern state was certain to be placed under the surveillance of the police if he ventured south of the Potomac or the Ohio, destined probably to be sold into slavery under state law, or permitted as a special favor to return at once to his home. A foreign-born citizen with his certificate of naturalization in his possession had prior to the war no guarantee or protection against any form of discrimination or indignity or even persecution to which state law might subject him, as has been painfully demonstrated at least twice in our history." Close quote. At that time, any state could have as thoroughgoing an establishment of religion as might be chosen, and persecute without limit. And yet there was no refuge under the national Constitution, because that document only said that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The Constitution did not say that no state should do it, and as the powers not delegated to the United States nor prohibited by it to the states are reserved to the states or to the people, it followed that each state might do all this without restraint at its own will. The 14th Amendment overturned this. Further, we quote, "But this rank injustice and this hurtful inequality were removed by the 14th Amendment. Its opening section settled all conflicts and contradictions on this question by a comprehensive declaration which defined national citizenship and gave to it precedence of the citizenship of a state. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside." These pregnant words distinctly reverse the origin and character of American citizenship. Instead of a man being a citizen of the United States because he was a citizen of one of the states, he was now made a citizen of any state in which he might choose to reside because he was antecedently a citizen of the United States. Close quote. Blaine, 20 Years, Volume 2, pages 312 and 313. Every such person, then, being by the supreme law a citizen of the United States first of all, and this citizenship holding precedence of every other, it follows that all privileges, immunities, and rights secured to him by the national Constitution are likewise his first of all, and take precedence of all others. This is as certainly true as it would be if there were no other citizenship known to the Constitution. Now, absolute freedom from any sort of an establishment of religion is an immunity, and an exemption from every kind of law prohibiting the free exercise of religion is the privilege of every citizen of the United States, for it is written, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." If there were no other citizenship known to the Constitution than citizenship of the United States, the only law-making power that could possibly affect the citizen would be Congress. The only government that could have anything to do with the citizen would be the United States government, and Congress is forbidden to make any law respecting religion or that would interfere with the free exercise of religion. Therefore, absolute freedom from any such thing is a privilege and immunity of every citizen of the United States by the Constitution. And now the second sentence of Section 1 of this 14th Amendment declares that, quote, no state shall make or enforce any law abridging the privileges or immunities of citizens of the United States, close quote. That is to say, that no state shall make any law or enforce any law already made which abridges, which restricts, which lessens the privileges or immunity of any citizen of the United States to be absolutely free in things religious. It practically declares that no state shall make any law respecting an establishment of religion or prohibiting the free exercise thereof. Quote, whatever one may claim as of right under the Constitution and laws of the United States by virtue of his citizenship is a privilege of a citizen of the United States. Whatever the Constitution and laws of the United States entitle him to exemption from, he may claim an exemption in respect to. And such a right or privilege is abridged whenever the state law interferes with any legitimate operation of federal authority which concerns his interest, whether it be an authority actively exerted or resting only in the express or implied command or assurance of the federal Constitution or law. Close quote, Cooley, Principles 247. Accordingly, this provision of the 14th Amendment annihilates the force of every Sunday law or other religious law or law abridging the free exercise of religion in every state in the Union. This is as plain a consequence as ever came or could come from any provision of law. It prohibits the persecution of any Seventh-day Adventist, Seventh-day Baptist, Jew, Protestant, Catholic, or anybody else by any state law which interferes with the free exercise of his religion. This is the effect of the provision as it is in its plain reading. This is certain. It is no less certain than the intent of those who made it was that this should be its effect. James G. Blaine was one of the leading spirits in the framing of this amendment, and after remarking of the first provision of this section, that it establishes American citizenship upon a permanent foundation, gives to the humblest man in the Republic ample protection against any abridgment of his privileges and immunities by state law, and that the first section of the constitutional amendment, which includes these invaluable provisions, is in fact a new charter of liberty to the citizens of the United States, with the matter before quoted. He continues, quote, the consequences that flowed from this radical change in the basis of citizenship were numerous and weighty, nor were these consequences left subject to construction or speculation. They were incorporated in the same section of the amendment. The abuses which were formerly heaped on the citizens of one state by the legislative and judicial authority of another state were rendered thenceforth impossible. The language of the 14th Amendment is authoritative and mandatory. No state shall make or enforce any law abridging the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Under the force of these weighty inhibitions, the citizens of foreign birth cannot be persecuted by discriminating statutes, nor can the citizens of dark complexion be deprived of a single privilege or immunity which belongs to the white man, nor can the Catholic or the Protestant or the Jew be placed under ban or subjected to any deprivation of personal or religious right. The provision is comprehensive and absolute, and sweeps away at once every form of oppression and every denial of justice. It abolishes caste and enlarges the scope of human freedom. It increases the power of the Republic to do equal and exact justice to all its citizens, and curtails the power of the states to shelter the wrongdoer or to authorize crime by statute. To Congress is committed the authority to enforce any provision of the 14th Amendment, and the humblest man who is denied the equal protection of the laws of the state can have his wrongs redressed before the supreme judiciary of the nation. Close quote. 20 Years of Congress, Volume 2, pages 313, 314. Such is the statement, the pledge, and the security of religious right in the states, according to the weighty, authoritative, and mandatory provisions of the national Constitution. It is true that each state constitution contains strong guarantees of the perfect freedom of religious right, yet the legislatures have ignored them, and the state supreme courts have interpreted them away. It is true that the national Constitution guarantees exemption from interference on the part of the government or any state with the religious right of citizens of the United States, yet the supreme judiciary of the nation has interpreted into that Constitution the establishment of the Christian religion as the meaning thereof. Congress, in its Sunday legislation, has put in the national law the very religious idea that has been set up by the states, and the executive has approved it. Thus, so far, the national power, instead of maintaining the high dignity which the people have given it forever to protect the privileges and immunities of citizenship of the United States from invasion by the states, has abandoned its high station and has gone down and actually joined the states in the invasion. Nevertheless, the right of the people still abides. The Constitution, as the people have made it, is still the voice and will of the people. It still guarantees privilege, immunity, and freedom to citizens of the United States. Only as the agencies appointed by the people to maintain these guarantees have failed to do it, the responsibility and the right now devolve upon the people themselves to see that it is done. Slavery and established religions, twin despotisms, existed in the states at the time of making the nation. The makers of the nation, finding it impossible to do away with them without risking the loss of all, yielded to the necessity and left them standing as state institutions only. When by the Dred Scott decision and congressional legislation the attempt was made to nationalize one of these despotisms, the people arose in their majesty and reversed that decision and destroyed that despotism, and with it all other, even in the states. Now, however, the other despotism has reared its hateful head, and by means of the Christian nation Supreme Court decision and congressional legislation, this is sought to be nationalized. Will the people, yea, will not the people rise once more in their majesty and reverse this decision and set the national power back again at the height and dignity where they placed it when they destroyed the other despotism? This is the duty. This is the task. This is the right of the people of the United States. True, now as before, the wealth, the popularity, and the power of the country, the power of the state and church, and of the church and state united, are all against us. But God and the right are for us, and with the immortal Lincoln, we must say, quote, we have to fight this battle upon principle, and upon principle alone. So I hope those with whom I am surrounded have principle enough to nerve themselves for the task, and leave nothing undone that can be fairly done to bring about the right result. Close quote. Springfield, Illinois, July 17th, 1858. Political Speeches and Debates, page 145. Let us never rest until there is created such a public sentiment that every court will be ashamed to use the term Christian nation, for public sentiment is everything. With public sentiment, nothing can fail. Without it, nothing can succeed. Consequently, he who molds public sentiment goes deeper than he who enacts statutes or pronounces decisions. He makes statutes and decisions possible or impossible to be executed. True, in the effort to create this public sentiment, we shall be unpopular. We shall be scoffed at. We shall be reviled. But in this we are right, absolutely and eternally right. Then let no one be slandered from his duty by false accusations, nor frightened from it by any menaces of dungeons. Let us have faith that right makes might, and in that faith let us to the end dare to do our duty as we understand it. Many times the people may refuse to listen, as at first, even in his own hometown, they did to Abraham Lincoln against slavery. Once in 1855, in Springfield, Illinois, Lincoln was advised to speak on the slavery question. Mr. Herndon, his law partner, spread great posters through the town, employed a band to march the streets, and had the bells rung to have the people come. Not a soul came to hear but Herndon himself and the janitor of the building. Yet Lincoln made the following speech, quote, Gentlemen, this meeting is larger than I knew it would be, as I knew that Herndon and myself would come, but I did not know that anyone else would be here, and yet another has come, you, John Payne, the janitor. These are bad times, and seem out of joint. All seems dead, dead, dead. But the age is not yet dead. It liveth as sure as our Maker liveth. Under all this seeming want of life and motion, the world does move nevertheless. Be hopeful. And now let us adjourn and appeal to the people. Close quote. So it is now said, to every reader of this book, Let us appeal to the people. Yea, though they will not listen, still let us appeal to the people. It is the only right course. The people must do the work. Will the people awake and arise and assert and maintain the rights of the people? This is the end of chapter 12. Rights of the People by A.T. Jones, Appendix A, the Declaration of Independence. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute a new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence, indeed, will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shown that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government, and to provide new guards for their future security. Such has been the patient sufferance of these colonies, and such is now the necessity which constrains them to alter their former systems of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. He has refused his assent to laws the most wholesome and necessary for the public good. He has forbidden his governors to pass laws of immediate and pressing importance unless suspended in their operation till his assent should be obtained, and when so suspended, he has utterly neglected to attend to them. He has refused to pass other laws for the accommodation of large districts of people unless those people would relinquish the right of representation in the legislature, a right inestimable to them and formidable to tyrants only. He has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records, for the sole purpose of fatiguing them into compliance with his measures. He has dissolved representative houses repeatedly for opposing with manly firmness his invasions on the rights of the people. He has refused for a long time after such dissolutions to cause others to be elected, whereby the legislative powers, incapable of annihilation, have returned to the people at large for their exercise, the state remaining, in the meantime, exposed to all the danger of invasion from without and convulsions within. He has endeavored to prevent the population of these states, for that purpose obstructing the laws for the naturalization of foreigners, refusing to pass others to encourage their migration hither, and raising the conditions of new approbations of lands. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. He has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. He has kept among us in times of peace standing armies without the consent of our legislature. He has affected to render the military independent of and superior to the civil power. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. For quartering large bodies of armed troops among us, for protecting them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states, for cutting off our trade with all parts of the world, for imposing taxes on us without our consent, for depriving us, in many cases, the benefits of trial by jury, for transporting us beyond seas to be tried for pretended offenses, for abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government, and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the powers of our government, for suspending our own legislatures and declaring themselves invested with power to legislate for us in all cases whatsoever. He has abdicated government here by declaring us out of his protection and waging war against us. He has plundered our seas, ravaged our coasts, burnt our towns, and destroyed the lives of our people. He is at this time transporting large armies of foreign mercenaries to complete the works of death, desolation, and tyranny already begun, with circumstances of cruelty and perfidy scarcely paralleled in the most barbarous ages and totally unworthy the head of a civilized nation. He has constrained our fellow citizens, taken captive on the high seas to bear arms against their country, to become the executioners of their friends and brethren, or to fall themselves by their hands. He has excited domestic insurrections among us, and has endeavored to bring on the inhabitants of our frontiers the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. Nor have we been wanting in attention to our British brethren. We have warned them from time to time of attempts made by their legislature to extend an unwarrantable jurisdiction over us. We have reminded them of the circumstances of our immigration and settlement here. We have appealed to their native justice and magnanimity, and we have conjured them by the ties of our common kindred to disavow these usurpations, which would inevitably interrupt our connections and correspondence. They, too, have been deaf to the voice of justice. We must therefore acquiesce in the necessity which denounces our separation and hold them as we hold the rest of mankind, enemies in war, in peace, friends. We therefore, the representatives of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do, in the name and by the authority of the good people of these colonies, solemnly publish and declare that these united colonies are, and of right, ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all of their acts and things which independent states may of right do. And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. Massachusetts Bay, John Hancock, Samuel Adams, John Adams, Robert Treat Payne, Eldridge Gerry, New Hampshire, Josiah Bartlett, William Whipple, Matthew Thornton, Rhode Island, Stephen Hopkins, William Ellery, New York, William Floyd, Philip Livingston, Francis Lewis, Lewis Morris, New Jersey, Richard Stockton, John Witherspoon, Francis Hopkinson, John Hart, Abraham Clark. Pennsylvania, Robert Morris, Benjamin Rush, Benjamin Franklin, John Morton, George Clymer, James Smith, George Taylor, James Wilson, George Ross. Connecticut, Roger Sherman, Samuel Huntington, William Williams, Oliver Wolcott. Delaware, Caesar Rodney, George Reed, Thomas McGreen. Maryland, Samuel Chase, William Paca, Thomas Stone, Charles Carroll. Virginia, George Wythe, Richard Henry Lee, Thomas Jefferson, Benjamin Harrison, Thomas Nelson Jr., Francis Lightfoot Lee, Carter Braxton. North Carolina, William Hopper, Joseph Hughes, John Penn. South Carolina, Edward Ruthage, Thomas Hayward Jr., Thomas Lynch Jr., Arthur Middleton. Georgia, Burton Gwinnett, Lyman Hall, George Walton. The end of the Declaration of Independence and the names of those who have signed it.